Hello class, welcome again to our lectures in Judicial Process CJ 379. Today is lecture for January 24th, and it will cover the role of the judge in the judicial process. We're bouncing over the defense attorney for today because I want to focus on those two parties that are most responsible for the administration, for the functioning, for the overall supervision and execution of what is the system, as it were. The defense attorney is somewhat of an outlier, that as almost a person looked on from the outside who has to establish themselves coming in through a very competent practice. But the judge is akin to the prosecutor, but I would say a little less important despite our perceptions from the media, from certain cases, maybe our own personal experiences, and just from societal standards. The judge is looked upon as sort of a legendary, impartial decision maker, severe in nature, presiding over everything and making the final decision. That's the conventional way of looking at it, and the text pokes a little bit of criticism at that, which I think is appropriate. A judge really, in my opinion, is less powerful than a prosecutor at the local level. We're talking about state courts. I think federal courts are a lot different. A federal judge, I think, has a lot more power in many circumstances, especially in the recent several decades where the federal system has been dictated by sentencing guidelines that draw lines and particular pigeonholes for every case, and the judge really administers that, and it's the judiciary that helps to set that, so that exercises a lot more power than in the state system. But even so, in the prosecutor's vantage point, the judge is still almost at the equal level, because the prosecutor, you will hear in federal systems, will bring the grand jury, will bring charges against high-profile people, so that's probably still a stronger office. But still, the judiciary in the federal system, a person can end up going to become an appellate judge, which is a much stronger position than in the state system, could become a Supreme Court judge from a federal judgeship. Many of the Supreme Court judges that are currently sitting on the Supreme Court were federal judges. Many were not. But we're just talking about state court judges here, and in my opinion, the conventional wisdom about the role of the state judge is a little overblown. So, for example, the power to bring charges is not in the hands of a judge. That used to be the way it was in the Middle Ages, and so maybe our conventional notions of what the judge is today are kind of drawn from the far-flung past. But in reality, the judge has no decision-making power. There's a lot of procedures that allow attorneys to select judges. So, for example, there's the power to remove a person as a judge for no reason at all. Almost every state code has it. You don't like the judge, you bounce him, to be crude about it. And I practiced with several reputable defense attorneys in Milwaukee and Madison, Wisconsin, and seen the experience in Minnesota as well. And I've heard stories about judges approaching defense attorneys sort of crestfallen, as it were, because they've been removed so many times by a prominent defense attorney, sort of asking, or winking, what gives, what can I do better, kind of hint, hint. So, as you can see, even compared and facing a defense attorney with much prestige, a judge can be kind of manipulated to a certain extent. And you will often find as well, if you pay attention in a courtroom setting, the lawyers are often more intelligent than the judges, and the judge is really relying on, to a great extent, what those parties bring to the table, having focused exclusively on their side of the case, where the judge has so many cases to deal with and often doesn't have time or really the intellect sometimes to get the job done without those two parties. So the judge's role is not as all-controlling as one might imagine. So the book is really correct about that. Another vignette about this is not just procedurally do parties like a lawyer on the defense side or on the prosecutor side have much power to bounce a judge. There's also political pressure that can be brought that can sometimes affect a judge from the public on the prosecutor side, and even from the defense side, depending on how powerful the defense is in a given locality. So keep that in mind. the judges have so many cases. One of their frustrations is that they have so many cases that it's really difficult to be all influential in one particular case. The exception to this impression that I have is really sentencing in a criminal matter. In sentencing at the Superior Court level in Washington State, judges have a lot of power to decide between either side's proposition. They can often not even follow them, but that's sentencing. That's not the other elements of a criminal case. So we still have to keep in mind that the judge has a kind of limited role. In addition, a judge is highly dependent on the prosecutor's office, frankly. So when the prosecutor presents a case, the judge is part of the state apparatus, frankly, okay, just like the prosecutor is, or the county government. Either way, it could be a county judge. The judges are highly dependent on those decisions, recommendations by the prosecutor in sentencing. Sometimes they almost always lean towards those. So it's, again, the prosecutor determining what role the judge should have really in deciding. I mean, laying out the ground rules and the judge coming close to it. Sometimes the defense attorney, on the other hand, is highly influential, and the judge will split the baby, leaning towards the defense in some cases, but for the most part, on average, will decide their sentences or make their decisions based on some kind of happy medium between the aggressive arguments of a prosecutor and the compassionate arguments of a defense attorney. So I would say the place in which, besides sentencing, the place in which the judge has the most power is administration of the system. So that is deciding which cases will move the fastest, which cases will be granted continuances, prioritizing the presentation of argument on a given day. The judge's staff sometimes are trained to do that. Sometimes a judge, we used to have these in Wisconsin, a judge, we would call them the rocket docket judges. Some judges would just make a blanket decision that their cases were going to move faster than everybody else's. So they would impose strict deadlines in which things had to be done, and strict timelines, really literally follow the letter of the law in terms of a fast trial. So they would try to get their cases done much faster than other judges. But there's limits to that power too, because sometimes a case comes along in which the judge cannot control that, and if they try to control it too much, the higher judges that review their decisions will sometimes reverse their decisions because they're being too unreasonable or bullying to the parties that need more time to figure something out. The litigation can get very complicated, and the judge can't just impose firewalls and deadlines that are arbitrary. Many judges try to do that, but often they end up having a jurisdiction that's very closed-minded, where other talented counsel don't come into that jurisdiction because they've been turned off by the way it's handled. That was the case in Wisconsin, where I had a county that the judges were known for having a rocket docket. They get bad reputations, and it's really not good for them in the future to have bad reputations for being kind of knuckle-headed or just too imposing. So that even though they have power to administrate and select their staff, for example, select the dockets, move cases faster in some situations, and move them slower, there's really still a big limit on them in terms of making sure their decisions pass muster on appeal. That is, making sure those decisions are approved on appeal. So another thing a judge looks at is whether he or she is going to have their decision reversed on appeal, and it's probably the biggest haunting thing that a judge has, is to see a higher judge turn them around and say you made the wrong decision and have to make a decision on a case all over again. It's a big deal for judges. So why then? Why would a person want to become a judge? You might be wondering if there are all these problems, including, as the book notes, large caseloads that are ever increasing every year and putting pressure on judges to move their cases fast, political pressure coming from the public, from the press, from conservative groups, because maybe a judge is being too soft on crime. So one might ask, what is, despite these fallbacks, what is the joy, or what is the incentive to become a judge? And I will just say one word. One of the reasons that people become a judge is because of prestige. The prestige in an occupation such as the law often leads to quick appointments to other offices, such as cabinet offices for the governor of the state, the governorship itself, the state Supreme Court, which is an entirely different matter, where the prestige is different and the cases are much smaller and they get to control their caseload. Long appointments is another issue that attracts judges. Long appointments, I think, are an element of prestige. Some judges are judges for life in the federal system. In the state system, the judges, on average, probably serve for around 8-9 years, and they're either moving on from there or getting reelected and can serve for their entire careers if they're good judges, and they keep close and are always in favor in their political groups. So that the long tenure of a judge, I think, is a big prestige issue. The ability to have higher office, okay, and I think that's where the rub is. The ability to have higher office is what keeps those judges on their toes, making the right decisions, and that makes the system function more smoothly, because these judges are ever wanting to exercise power at a greater level, such as the governorship, or such as some kind of prestigious office. A special prosecutor, sometimes in the federal system, you'll see would have been a judge in the past, or just the ability to go back into private practice and attract a higher level of clientele because you've been a judge. I've been in those law firms too, not personally employed in such a law firm, but I've known and rubbed shoulders with people who had former judge staff on their staff or former judges themselves in their law firm. It brings the law firm greater prestige and thus higher paying clients. So in the end, higher pay is a reason that judges go into being judges as well. They're more highly paid than other judicial system staff, except for maybe higher paid defense attorneys. And they're always looking for their cases to become trend-setting cases, so cases that they decide becoming the norm. A final reason I'm going to why a judge really would enjoy their profession is because a judge gets to set policy, essentially, even though people look askance at that and think a judge should not be setting policy because a judge is not elected. Essentially, by ruling in a certain way, setting precedent over time in cases, a judge gets the attention of the bar, that is the practicing attorneys, the public, the upper courts, for being a good judge, that their decisions are influential and that essentially other people will follow in their footsteps in terms of the way maybe the police department works, or the way in which defense attorneys argue, the way in which the state's policy is driven. It could be anything from land use to criminal sentencing. Judges, I think, want to be judges because they're setting policy in far-flung areas, and that also makes them prestigious as potential cabinet nominees, or hired court judges. So ample reason to become a judge, don't get me wrong, but don't also be deceived by the kind of conventional wisdom that's in the media, or maybe that's handed down from generation to generation, that a judgeship is just sort of the end-all be-all of positions. If I were personally a judge, it's a lot of work. I knew a lot of defense attorneys that would never have done it, not to mention the fact that it's hard to do from the defense bar. But if I were a judge, I think one of the reasons I would be a judge is because I was looking farther in the future, to be in a bigger law firm, or to be in the governor's office, or to be in a higher court. So that's it sounds kind of crass and opportunistic, but that's really the way it works. I'm not really a policy wonk here in my brain, so I'm not attracted by the idea of shaping policy and making the country run along some of the ways that I think. But every person would have their different reasons. But never underestimate prestige. When a judge is hearing a case that, say, you bring, or you're a law enforcement officer aiding the prosecutor's office in a case, that judge is not just thinking about your case, although if you're law enforcement, to a great extent they are, but they're thinking about how their decision is going to reflect on future generations, on other courts, on other policymakers, the public. So that's who's got their ears. So you frame your case so that the judge will look good in terms of those parties, that's a large part of it. Another element of it for the policy wonk judges is the judges that I've known that were the smartest judges always want to make the correct decision under the law. and be able to impart fair justice in their courtrooms. And so you're presenting your case as the most just option, for example, and I've seen those judges struggle mightily, in front of 3 or 4 or 5 different attorneys in a complex case, and they'll bounce from one attorney to the other, peppering them with questions. You'll see this as well in the Supreme Court of the United States. And they really want to come up with the decision that's going to be correct and respected. So they're looking, and they memorize the rules of evidence, or they've memorized sentencing laws, they've memorized the rules of appeal, and so they've got this all in their head, and they want to make that correct decision. So there's the judges that are really positioning themselves for higher office, then there's the ones that are the policy experts that want to make that correct decision. I would say the latter are less common, but more enjoyable to bring a case before. I've had some of those judges do that, and I had one very high-profile case involving an alleged sexual assault, in which I, by accident, got the policy judge, the chief judge of the particular district I was in, and everybody was surprised because he normally didn't handle criminal cases. And there were 3 of us lawyers on one side, the prosecutor on the other, a very large case, and I ended up winning my case in front of him. But I could tell he was mightily working to get the right decision under the rules of evidence, under the rules of felony criminal cases. He even, at the very end of the case, when he dismissed my client's case, he almost stuttered when he mentioned that he was dismissing the case, because literally he wasn't dismissing it, he was dropping the felony charges and amending them to criminal misdemeanor charges, much less serious charges. But he was so intent on making that right policy decision that he sort of lost sight of these minutiae of what these little details about what the charge should then be called. But it was unimportant because he was such a smart judge, and I really respected him from that time forward. So if you have a judge like that, the policy-oriented judge, as opposed to the judge that's positioning themselves for future office, always remember, you better know your facts really well, know what the law is, almost like you're a judge themselves, so you can guide that judge and push them in the right direction, because then he'll never forget you, she'll never forget you, and you'll have a very enjoyable practice having been straight with that judge and knowledgeable about what the case was about. So to wrap up our talk for the day, I would say when you focus on the judge, focus on what their powers are, not necessarily all the details about how they get elected, appointed. Those are also in the text, but I would rather have you understand what the specific little details are about what makes a judge a judge. What's the animal that is a judge? And we'll discuss that probably in future discussions, forums concerning our case up close, which again is the Duke lacrosse players case. We'll be discussing that in our next segment on the defense attorney. Thank you.